of 2023. And what that means is that if you go to trial and you're found guilty, you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please, for me. Thank you. And I have here on the tablet a plea bargain rejection that has your signature with Mr. Parker's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to waive that enhancement for habitual for a 20-year sentence in prison. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and go to trial? And is there any reason to believe that that offer would change?
No, Judge, it would go up substantially.
So I want to make sure you understand, I don't want to accept that offer after today either, okay? And so if you change your mind, you can plea open to the court or just. All right, ma'am, you're Victavia Sanders?
Yes, ma'am.
And Ms. Sanders was previously here in cause number 2239884, entered pleas of true to counts 2 and 3, and a motion to revoke community supervision. I received an updated pre-sentence report. We're here for a sentencing hearing. Has everyone had an opportunity to review that report?
Dr. Feed, Judge. Yes, Judge.
Are there any additions or corrections to the report?
Your Honor, my concern, I guess I can address this after Mr. Smith had the opportunity to present evidence on the new offense, was that the recommendation appeared to be predicated on an assumption that the new offense had been proved up, and that was going to be my issue with the pre-sentence report. Of course, if Mr. Smith is prepared to prove that.
Okay, let's go through that.
The necessity for me to go into that.
All right, we'll go through that first. And it's my understanding, and we spoke earlier kind of off the record, that the officer involved is unavailable, but that Mr. Smith has his body cam video footage from that date, and there's no objection to him putting that on as evidence in this hearing. Is that correct, Mr. Kimler?
Yes, Your Honor, that's correct. My understanding is due to the exigencies of the officer being involved in the shooting, he's on administrative leave and is unavailable to testify. I therefore don't have any objection to the body cam being played in his absence.
Thank you, Mr. Kimler. And just let me know when you're ready, Mr. Smith. And Ms. Lopez is here. Thank you, Ms. Lopez. And at the appropriate time, if you have anything to add as well, I'll give you an opportunity to do that. And so the allegation in count 1 that was not pled true to or not is the allegation of a new theft of property from July 31st of 2025 here in Jefferson County. To count 1.
There is also the footage from the inside of the car where both are detained, where she actually speaks to the other defendant without the cops being there, and she talks about how she was here and you had told her not to do this anymore. But I think that first video kind of sums everything up.
All right, any evidence with regard to count 1 before I make my finding?
Evidence, Your Honor, is in testimony.
And anything that could...
I'm looking at this trying to figure out if that's a legal search. I mean, she appears to be detained, so it's not a Terry search. It's a warrantless search, obviously. She's not under arrest and being searched at the jail.
They didn't search her. They said, if you have something, take it out. She took it out and she placed it on. They didn't even have to get to the search.
I guess she could have refused and remained silent.
But she didn't, and so...
She followed the direction. And there's no Miranda issue since she wasn't arguably in custody. I don't have any argument. I will go ahead and object if that's an illegal search.
All right, that objection's overruled. I am going to find count 1 true. And so, let me see, I need to, counts 2 and 3, she pled true to, so there's a finding of true, count 2. Again, everyone's had an opportunity to review that pre-sentence report. Mr. Kimler, you may make argument with regard to punishment.
Yes, Your Honor. At this stage now that the state has offered evidence as to count, as to be a new offense, and the court's found that to be true based on the evidence, I think the recommendation comports with the state of the record. I would, again, defer to the probation department, but I think that they're seeming to indicate that the court is to keep her on probation, that she enter into the ISF program, cognitive track, and I would defer to that recommendation in lieu of revocation.
Mr.
Or proposal, I suppose, I don't know if it's an actual word.
With the pending charge of this theft, she's not eligible to go to ISF.
She's, if I may, she's set on that today. I can resolve that today in this.
No, it's pending in felony court.
It's here,
Oh,
it's
is it here?
mine.
Okay.
Because of the prior
All right.
thefts.
All right,
She's done with misdemeanor
right.
thefts.
We could resolve that perhaps today, Your Honor, if the board.
I mean, I'm, go ahead.
The state, I feel like we have given her every possible chance to rehabilitate, and she has not taken that. We would ask that she be revoked and given, based on the number of thefts committed, that she be revoked and sent to the state jail for 2 years.
Ms. Lopez, do you have anything else to add to your updated
I put
report?
everything in my recommendation.
All right.
Do you want to address the judge?
Yes. I feel like I did, how can I say this? I feel like I can finish my probation off because of the simple fact, like, this is the longest I've ever been away from my kids besides when I did 8 months, but they was younger than me, and like, I was younger, and like, they understand what's going on. And I understand, and like me being away from my kids right now is really hard, because they be with my mama, and my mama had dementia, and she...
Stop with everybody else, because I'm not going to make my decision today based on the fact that you have kids or based on the fact that your mom needs you, because you weren't thinking about that day. So don't put that on me,
No,
that if I send you to prison,
Don't talk.
that I'm somehow going to be hurting your kids or hurting your mom. You've done that. You were on felony probation, and it sounds like if the other video was played, you knew exactly what was going to happen. If what Mr. Smith is saying is true, that y'all were in that car and you said, Judge West said, I better not do this again, and you did it again, it just makes me look like an idiot for giving you the opportunity in the first place. At some point, you have to stop. Some point you have to stop. Anything else?
Judge, even based on what she told probation is, she wants to be reinstated on probation. She was just with the wrong person. The girl she was with already took probation.
Right.
I wasn't the one stealing.
Yeah,
So she
I made a
doesn't
note of that.
Accept responsibility.
How is this my responsibility?
You accept your responsibility now that we saw it on a video. You didn't accept your responsibility. You said you were with the wrong person. I'm gonna tell you like I tell everybody else. You are the wrong person. She was with the wrong person. Y'all were with the wrong, you're all, if you're in there doing it, you are the wrong person, right?
Yes, ma'am.
So you didn't take responsibility. You haven't taken responsibility. You were given this opportunity after having felonies and going to state jail for the same offense, and I gave you a probation, and I said, don't do it again. So at this time, I'm going to find again, count one, that there was sufficient evidence to find count one true, find it true, find that you pled true to counts 2 and 3, find sufficient evidence to revoke your probation, and at this time, revoke your probation, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to...
I'll get the other one worked out today.
Okay, I'll hold it while y'all do that, and then while I'm doing that, I need a, yeah, I'll hand you the trial court certification in just a minute after y'all do that on this case that shows this was not an agreement. You have some limited rights to appeal. If y'all want to go visit about the other one, I'll hold it. All right, go ahead, go back that way. I know, I almost wish that we had done it just for,
Because they're giving the wrong name and date of birth to the cops. I was told when she was a juvenile, she was only 16.
well, and you know what, now that you did that, maybe I should have, because it might have been worth it. Her last was 8, so I figured, okay, what are we doing here? This is an MTRP.
Yes, ma'am.
All right, are you Latrick Williams? And will your client waive the formal, oh, never mind. I just remembered what we were doing. All right, so it's cause number 24 DCCR 1791. Mr. Williams was on probation, on a deferred probation, let me just go back so I can get everything correct on the record, for theft of a firearm, which is, everyone agrees at this point, a state jail felony. And the paperwork for the motion to revoke read third-degree felony, and we all just went with that. And I revoked Mr. Williams' probation. He was sentenced to TDC, and it has now come to our attention that that was obviously a mistake, and that we need to get him sentenced correctly to the state jail felony. So with that being said, I would entertain a motion for a new trial, even though it is outside the time.
We would move for a new trial at this point, Judge, based on the corrections.
Any objection to that?
No objection.
All right, then at this time, I will grant a motion for new trial, even though it is outside the time frame to do that. And so what that means is we're back like nothing happened before that. The case is still pending, you're on the probation, but it's like I did not revoke you, so we're kind of starting over at that point where we were just in October, okay? And it's my understanding that you guys have visited and come up with an agreement with regard to punishment for the state jail felony, correct?
Yes, ma'am.
And so I think to make the record clean, let's go back through the motion itself, and I'm going to get pleas of true or not true. It looked like before it was 1 through 3 and then 5 and 6, and so I'll just read those that you pled true to already, okay? And so will he waive the formal reading of that motion again? And so let me, I'm just going to print it. It'll be easier for me to, oh, thanks. So in 24 DCCR 1791, I've got a motion to revoke your unadjudicated probation. Shows that you were placed on Would the state like to make a oral motion to amend the motion to adjudicate?
Yes, Judge.
Okay.
No objection.
To read?
To read that it is a state jail felony.
Okay. No objection to that. Okay, so again, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 24th, 2024 for the state jail felony offense of theft of a firearm, and that was a 5-year deferred probation. Is that correct? And it alleges in count 1 that you violated your probation by committing the offense of unlawful carrying a weapon May 12th of 2025 in Jefferson County, Texas. Is that true or not true? True. Count 2 alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County. Is that true or not true? True. Count 3 alleges that you committed the offense of minor in possession of alcohol May 25th of 2025. Is that true or not true? True. Count 5 alleges that you committed the offense of resisting arrest or transport May 27th of 2025. And is that true or not true? And then count 6 alleges that you failed to report as directed February 10th and May 15th of 2025. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 5, and 6 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
I have some documents on the tablet like we had before that you've done today with Ms. Holmes. Did you go over those with her before you signed them?
Yes, ma'am.
You fully understand them?
Yes.
And you understand if I follow this agreement, you'll be waiving any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you another copy of that admonishment regarding your ineligibility to possess a firearm or ammunition. I already read that to you last month. I'm not going to read it again. You understand you cannot possess a firearm because of this conviction in Texas, right? Okay, you can go back with the bailiff. Thank y'all. Again, you're Victavia Sanders,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
You will, Your Honor.
Ms. Sanders, in cause number 25, DCCR 1351, you're charged with the state jail felony offense of theft of property with previous convictions, and that is from July 31st of 2025. The indictment alleges you were previously convicted of theft November 13th of 2017, and then again April 15th of 2019. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with? I have some documents here on the tablet. I guess it's coming. The documents on the tablet that have your signature on them, that the state's marked as exhibit number 1, did you go over those documents with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Why is it less than what I just
Cost of
did?
back time, maybe, I think she has less back time in the new case.
All right.
Just so it lines up on the release date.
It's Christmas.
It's Christmas also.
We'll go with that. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Sanders is not competent?
There's none, to my knowledge.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find those prior counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of theft with prior convictions. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It will run concurrently, which means that together at the same time with the other case. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. And I want to make sure you understand, don't go do this time and get out, keep doing the same things, because it can get worse. Today, what could have happened is the new case could have actually been stacked on top of the other case. I could have given you up to 24 months on one and then stacked the other. So you already know now, we're not playing games. You've got to stop, okay? All right. You go back with the
Your Honor, for the record, as part of the plea bargain, she's waiving appeal on F-22-39884. She's
Okay.
waiving the appeal.
Thank you, Mr. Kimler. All right, you can go back with the bailiff. Would y'all, I'm going to print one, if you'll print the other, please. Same TRPs. Robert Joseph, if you'll print the somebody, print the second one, please. Give me just a second. Get these printed out. Look, I can probably get it before you with your computer.
I pulled it up now.
You got it?
Yes, ma'am.
Okay. All right, well, you're Robert Felix Jr., Joseph Jr., and will your client waive the formal reading of the motion in each case?
He will, Your Honor.
In cause number 21-38610, I have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the first-degree felony offense of manufacturing or delivering a controlled substance, and that was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes.
in cause number 21-38611, I also have a motion to revoke your community supervision. Shows that you were placed on probation May 8th of 2023 for the third-degree felony offense of unlawful possession of a firearm by a felon, and that was also a 10-year sentence that was probated for 10 years. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of public intoxication October 3rd of 2025. And is that true or not true?
True.
Count 2 in each case alleges that you failed to maintain your financial obligation to the GPS device company, failed to charge that as well. And is that true or not true?
True.
And then count 3 in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 in each case freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I go along with this agreement today, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if I go along with this agreement, that this is a huge opportunity based on your history and what you're in here for?
Judge, if, may I provide the
Sure.
explanation?
Yes, ma'am.
to the court? I certainly agree with what the court just said. I know this defendant from his being here before. He's not somebody that needs to be in this courtroom. He's 18 hours shy of college degree. He was a college football player. He got totally off track.
Yeah.
And has just, I've spoken with him in the back. I've spoken with his probation officer. She asked that the court consider this sanction and allow him to be released for the holidays, with the understanding that the pretty low offer that Mr. Rojas and I had discussed previously is now off the table, that he will be on zero tolerance if the court would allow, that he will have to continue to have that GPS on and show you that he can do what he's supposed to do with it. He was hemming and hawing back there about how much he spent on it, and I told him, in my opinion, he's going to have to prove to you that he can stay on that GPS and do what he's supposed to do and do what Ms. Bradley asked of him, what you asked of him. And if he does that, I'm willing to give him the opportunity, if you are, with the understanding that if he's back, I will ask for the full time.
So, and I recognize you as well, and I know you shouldn't be in here, and it looks like you were doing well for quite some time. And so I'm gonna do what everybody feels like you have the opportunity, your probation officer, the district attorney's office. Because of the nature of the offense and what was going on, at least for some amount of time, you're gonna have to wear the GPS monitoring device. And so I know it's not cheap. You're gonna have to get a job and figure it out. It's very important. It's charged at all times. It's paid for. I've gotta know where you are and that you're doing the right things.
Yes, ma'am.
If you do that for some amount of time correctly, it's always charged, it's paid for, you're up to date, then you can ask your probation officer to ask me if I'll let that go, and I probably will.
So I can answer actually directly.
They send me, so I have a box in my office that I get a pile of stuff from probation every single day. Early terminations, requests for monitoring device to be, all of those things. But they're not going to send it over and ask me on your behalf if you have not done everything you're supposed to.
They told me I had to hire another lawyer.
Well, they can send it over. Now, if you want to, a lawyer could file a motion, they can send the request over for you. But, and I'll take a look at it and see what all's been going on and talk with your probation officer again about how long you've been on it and what's been going on. If there's any change, I'll let her know. But for now, based on the new allegation, you need to get it, keep it, and then I'll reevaluate that, okay?
Yes, ma'am.
So this was a plea agreement, obviously, that I followed, and so you've waived any right to appeal. I handed you the trial court certification that shows that, all right? Good luck to you, sir. You can go back with the bailiff. Oh, and so, sorry, I feel like I skipped everything, actually. So the agreement was also for 60-day jail sanction, and that's with credit for time he's been sitting.
Yes, Judge.
And he has you've been in there.
Today's day 64.
Okay, so State tenders number 1.
Objection.
It's admitted. Any evidence that Mr. Joseph is not competent?
No, Your Honor.
All right, then I am going to, again, follow the agreement and continue you on probation, order that 60 days up front as a, but with credit for it as a sanction in both of your cases. And so you should be released today, it sounds like. Go straight to probation, get everything back in order, and then you'll be fine, okay? All right, good luck to you, sir. You need one too?
Thank you. I'm sorry, excuse me.
Good morning, are you John Willis? And will your client waive the formal reading of the indictment? Mr. Willis, in cause number 25, DCCR 1048, you're charged with the second-degree felony offense of burglary of a habitation, and that's from June 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Answer out loud, please. And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $300 fine. There would be a dismissal in misdemeanor cause number 25 CCCR 1654, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Speak up.
Yes.
The state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Willis is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. Ms. Malfino, what is the state's position with regard to bond?
Judge, I have no objection to a PSI bond in this case. The court will recall that on October 21st of this year, this defendant was before you with respect to a bond. The complainant was also here. Just to be candid with the court, she has been very back and forth, so to speak, about her desire to prosecute or not a misdemeanor versus a felony. I spoke with her again a few times yesterday. This is what she asked me to do, is put him on the felony probation with the court to supervise him. I would ask that in the interim period that we go back to those bond conditions, or PSI bond conditions, whatever we need to call it, that were a no contact with the complainant, a GPS monitor, and the fact that you ordered him to reside with his mom in Iberia Parish at 726 Mergery Street. He's just been unable to post that $7,500 bond that you gave him that day, so he's been in custody this entire time.
Okay, do you understand all of that? And you understand if I reduce your bond today, that those are all going to be conditions of your bond? I understand that Ms. Richards has gone back and forth, and you guys are going back and forth, but until sentencing and possibly beyond that, you're not to have any contact or communication with her. She can't give you permission. I think I went over all this probably at that hearing. She can't give you permission to violate my order, okay? She can't. So, and you're still planning on going and living with your mom in Iberia Parish, correct? So what I'm going to do, Mr. Willis, is reduce your bond at this time to $1,000. I am going to order pending sentencing if you make that bond. And do you think you'll be able to make the $1,000 bond? Okay. So you're going to be ordered to get a GPS monitoring device. And so the bond is lower. You're not going to have to pay a lot to get out of jail, but you are going to have to pay for and keep a GPS monitoring device on at least until sentencing, just so I know you're doing the right thing between now and then, okay? We'll discuss it again at sentencing. And you're ordered to live in Iberia Parish with your mom and remain in Iberia Parish except coming back to Jefferson County for court, okay?
Can I ask you something?
Uh-huh.
I have a son in Lake Charles. Would I be able to visit?
Yes, you can go to Lake Charles if to visit your son.
Okay.
So whatever, do you have court orders or do y'all just go visit? Okay. So the main thing is that you're not back here and you're not having contact or communication with Colette Richards, okay? All right, we'll see you back at sentencing. You can go back with the bailiff. Good morning, are you Tyree Hartley? And Mr. Hartley, in cause number 25 DCCR 0842, you're charged with the first-degree felony offense of aggravated robbery, and that's from April 22nd of 2025. Your indictment alleges that you were previously convicted of harassment by a person in a correctional facility, a third-degree felony, August 5th of 2013. And after that was final, you were convicted of evading arrest or detention with the use of a vehicle, a third-degree felony, December 21st of 2022. And then again, an evading arrest or detention with a vehicle, November 13th of 2023. And what that means is that if you go to trial and you're found guilty, you would be considered a habitual offender, and your minimum punishment would be 25 years in prison up to 99 years or life. Do you understand? Answer out loud, please, for me. Thank you. And I have here on the tablet a plea bargain rejection that has your signature with Mr. Parker's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to waive that enhancement for habitual for a 20-year sentence in prison. You have every right to reject that. I just want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject that offer and go to trial? And is there any reason to believe that that offer would change?
No, Judge, it would go up substantially.
So I want to make sure you understand, I won't accept that offer after today either, okay? And so if you change your mind, you can plea open to the court or to something else, but it won't be to that, all right? So I will put your case on the trial docket. Mr. Parker's been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Parker, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial, okay? You can go back with the bailiff. All right, everybody, I have to take...
This is basically a misdemeanor offense, but due to the nature of it, it's TBC.
Good morning, are you Adrian Banks?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a third-degree felony offense of harassment of a public servant in count 1 of that indictment, and that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving